trademark. So like that it will come different. So that is just a will take care of this entire process of right from the filing till last and for limited period, that means 20 years valid within the country of a grant. So if I file the patent application in India, it is valid here. If I am doing in the Singapore, it is Singapore. Like that, country to country it will vary. If you want to have a complete monopoly, you have to file in each and every country because the laws are different to some extent. So the novel innovation is the main crux for this patent, and invention step is another important thing. Steps, whatever methodology you are describing in the patent application is important. Whether it is having any practical insight or just like a casual approach. If it is any having the practical applicability and utility, that is again important. And the novelty, utility and application to the public and industry is very important. So how do the patents work? These are the different steps you can see. So initially right from the patent application, examination and publication of application, search and substantial examination and finally the grant application. Again it varies with the country to country the time requires to do the entire process. Once upon a time in India it's 1 decade, 1.5 decade it was taking in 90s. Now it is a game change is there, but not much improvement of course it is there. Sometimes within 2 years people are getting the patent. So that much fast and novel mechanisms the government has adopted. So in the entire life cycle management of patent, if you see, initially the preparation times take time, then the prosecution and the monetization. The only thing is preparation is your time, whatever duration you want to take, that is in your hand because you are the subject expert, you are the inventor, you know the strengths and weaknesses, this is within your hand. So you can approach the expert and write. But the prosecution, again, you cannot predict what the prosecutor is going to ask you, what type of queries he can raise it. That is completely based on how efficiently you write your filing, not an application. The next one is the monetization. Here, pledging, litigation, legal issues will be there. Here actually our knowledge is not at all enough. So the organization, whichever organization, agency is doing, their role plays important role in protecting your document. And the most important thing, all these things is second and third thing is not in your hand, as I mentioned. The first one itself is very, very important. Patent specification sections like a title and the field of innovation, the novelty in terms of that one. How you can show based on the prior art or the literature available, how do you project your observations, your data, your leads or observations into a highlight. That is very, very important. Otherwise in the initial screening itself your application will be dropped. Then finally you have to claims section will be there. The claims are based on your leads and observations only. There is not specific language will be there. That language exactly you have to use it, terminology. Then abstract, you have to give just an abstract and drawings, if any design and other things are there, complete drawing or flow chart or flow diagram you have to do, or process. Worldwide patents in 2024, if you see, China is the leading one, number of patents granted and the number of patents filed. So, because why I am giving you the both the columns is the speed of getting or granting the patent you can see. Wherever I have put the pink color font, here almost whatever filed they are getting within a year. See that much a fast, super fast mechanism is there in these countries. So our position is around 5th. That means 105,000, then 105,000 2024 filed and 64 were given. So you say around 64% or 65% our efficiency rate. Still better as I am telling you. Earlier when we filed paid 1.5 decade we fought. So the Germany and next Germany also surprisingly, I don't know the reason, Germany, because the most of the German patents are chemistry based patents. This is one of the thing I would like to mention because it's biology patents and rest of the things you can get easily dig out and know it. Chemistry patents is a Herculean task. Challenges will be very, very high. So the rest of the things are there here. And in India, the emerging trend in the IP ecosystem, if you see, the Make in India concept, the Skill India concept, the startup ecosystem, because all these Gen X generations, they have embraced the startup ecosystem and they want to secure their novelty. So that is where the patent ecosystem has burst like anything in India during the last 1.5 decade. And if you see that the right side one, it's not clear, but we think CSIR one is the third one. It is around 1810 patents CSIR is having. These are the other agencies whosoever is involved in India. So because, for example, this college is there, you can, if you want to file a patent, you cannot go as such because there are legal issues, procedures, so many things. You have to approach one of these agencies, then they will help you. You have to pay the fees to them, then they will help you to do. Like that, many associate agencies are there. So CSIR position is in the number 3rd. And the patent portfolio to CSIR, CFTRA, if you see, especially CFTRA, 166 are there as of now. And the Indian patents and international 93 patents were there. Again, in this one, different products are there. I mean, different categories in food. Bakery and cereal products and beverages, food machinery, like this. So many are there. So the beverage sector is having many such things. Similarly, the green color one, you can see the microbial fermentation products and fermentation products are having a maximum number. So India's IPR balance, how we will manage compared to the rest of the world? This is a question. So intellectual property rights are very important for encouraging the innovation and protecting the genuine research of the young minds. It is equally important to recognize that the global IPR framework has been reflected the interest of the developed nations. You see, there is always a fight between European countries, US, and also the developing nations. Now India, of course, is almost listed as a developed nation, but otherwise we were fighting with the developed nations, the other top countries, because their mandates are different, their interests are different. They want to completely hold the monopoly on that one, but India doesn't want that one. Public interest and public health is very, very important. So our laws are quite different from the European country laws, patented laws, and American patented laws. See, the pharma industry, especially during our days, I think Dr. Ajiraj also worked in Reddy Labs. At the time, top 10 world patents in pharma, if you see, 5 or 6 were Reddy Labs. Yeah, that was the thing. So, being Reddy Labs associated with our own Hyderabad firm, so we are having advantage. Suppose if the same Reddy Labs was in US based, I mean, completely the monopoly was there, you would cuff up a hefty royalty to them. So this is the difference between, I mean, important of the patent, which country you will file and all things. So what specific measures can be taken to better protect traditional Indian knowledge and the products from international patent claims? This is one important question. And how have other countries responded to similar issues? So I have a patent, I want to present, what is the response from the guy? You have to do the business, you should have maintained your good relations with the other nations for one or other, otherwise your commerce gets affected. So you have to balance both the things. And what reforms are being discussed or implemented in the international IPR system to address these loopholes? Every time upgradations will be there. So what are these updates you need to follow? One example I would like to mention. He is, I think, the senior people you might be knowing, he was the Arya Mashelkar, the then DG of CSIR. So in 90s, actually, several traditional Indian products and knowledge systems were historically appropriated or wrongly patented. One is Basmati patent as a Taxmati by a University of patent, and also the turmeric. These two are there. Actually, the Basmati rice is our own Indian geographical products, and turmeric since ancient times India is using. And everybody got, because of these two things, so you cannot export the turmeric, you cannot export the Basmati to other countries. If you want to do, you have to pay royalty to them. What a loss to economical loss to us, and also knowledge erosion. So that is why CSIR has jumped into this action at the time, and they developed documentation, enough documentation to the US patent trademark organization, and ultimately we could able to make the US patent office to withdraw their patents. Especially the turmeric, lot much literature, Ayurveda, what not, Siddha medicine, everything was there. But everything was almost defended by the USPTO also for one or other reason. because these populations migrated to continental drifts from one to another thing. Ultimately, the one thing that protected our turmeric patent above all the basic traditional documentation is one Unani medicine. In Unani medicine, the doctors, whosoever doctors in those days, they use the turmeric to apply onto a small knife that used to make a cesarean operation. That protected India, and ultimately USA has withdrawn that patent. Similarly, the basmati rice. So the basmati rice, you all enjoy this one. There are physicochemical properties are there. Grain will be this much. If it cooked, it will get elongated. Flavor, fragrance, texture, so many number of properties are there. These are all not pertinent. So 45 varieties of very well established, quite old germplasm traditional things were given to the CFTR at the time. And the CFTR has completely provided the physicochemical characteristics, including the flavor compound, that is 2-IP, 2-isoperoxidase will be there. This is the actual basmati flavor, even in pandanus you will get it. Okay. Then this quantity is very, very important. This much high quantity is there in our thing. But the Texmati variety, what that American universities developed, they also said, we also, our thing is the flavor compound is more this one. And they said, even in tiger urine, you will get the basmati flavor. 2-IP compound will be there. That is an argument. Then how do you defend this one? Then again, it is not 2-IP alone, this major compound. There are signatory molecules, 60 other molecules are there. That is what CFTR established. And they provided, and ultimately, the basmati patent also was withdrawn by the US. You cannot use the word basmati or Texmati or related word. You use a fragrance rice. So here the things were massive claim reductions are this one, and out of 20 different patent claims, 15 claims were withdrawn. So basmati name was and our all export rights were restored. Then after that India enjoying this one. Then the fight was between Pakistan and India for basmati. Actual basmati got its origin in Sindh province in Pakistan. Anyway, it is erstwhile Bharat, so it is settled. So the nutmeg mouthwash patent, this is very recently, see, that was there. Then TRIPS agreement, Cartagena protocol, so many things were there. You cannot claim even a traditional thing. So what happened is the mouthwash, the nutmeg is commonly used in the traditional medicine in all herbal formulations for mouthwash. The Colgate Palmolive has taken a patent. Then again CSIR has jumped into this one, and they have provided enough documentation, evidences based on the traditional knowledge that was withdrawn. Then the spice and herb patent. Colgate filed a claim that the EPO, that one, this one, against, at the time what happened is the TKDL was established, Traditional Knowledge and Digital Library was established by the CSIR to look after all these cases of post basmati and turmeric thing. Now entire India scripts, knowledge, traditional, everything is reposited there. Now completed the translation into the digitalization also. It's easy to learn. The spice herb, this one also withdrawn by the Colgate. And Lal Dantmanjan. So even right from the childhood, we know that one Lal red powder, tooth powder and all things. Similarly, Nanjangud tooth powder, all things, all famous. This also they claimed. This was also enough evidence was given by the India, especially the Dabur and All India Ayurvedic Medicine Association. These people spent a lot of time. Ultimately, this was also withdrawn by the Colgate Palmolive. So these are all some examples I am giving to you. 249 patents were taken on yoga alone in 2004 by various things. Most of the things got withdrawn later. And 2,300 in 2005 at various international patent offices. Because if not, Indian government may not give you. Maybe Singapore government will give you, or some other country may protect you. But you cannot, you will lose the business there. So that's why that was also there. Another example is Unilever. The British Dutch consumer goods company had applied for a patent for a mixture of grape and apple and berry juice for reducing heart diseases. This was there in our traditional thing. We have provided enough thing how this combination of decoctions of whiteys and grape apple thing cures everything. That was also withdrawn. And an applicant had claimed a patent on herbal composition comprising chana dal, that is Caesar Bengal bromide, and for the treatment of obesity and non-insulin. This was also stopped. Then an Italian company had sought a patent on cancer treatment using essential oils and some component from the Vistacia, that Vishamushti or something. That was also TKDL intervention stopped. So these are all the various victories for the Indian government. So that is why India wants to strengthen its IPR regime. So the digitalization of the patenting process completely done thanks to the Government of India and CSIR, especially TKDL. That's why the patenting process, the filing and awarding process is very fast now, and very strict enforcement mechanisms were there in India. So you might have heard about this guy, Gurtej Singh Sandhu. He got Padma Award in 2020 or something, I think. At the time, 21. He is a IIT Delhi product. He moved to US. He is an engineer. I think he's totally electrical engineering. He is the highest patent awardee in the world, even more than the Edison. 1382 things. And 90% of his things were translated to utility in US. Now he is the CEO of Micron in US. So we should have, youngsters should have an inspiration. India, at the time it was very difficult to have a patent. Many people, brain drain was there. This is one great successful story. And nowadays, from biology, of course, the theme is on chemistry, but most of the bioactive molecules, just general context I am telling you. Genome editing technology is there. It is also, if you really use that original genome editing construct and other things, Cas9 technology, you have to pay the royalty. That's why the DBT and the Government of India, I think last 6-7 years, they have launched software schemes. You have to design your own knocking things and vectors and other things. Otherwise, you have to pay the royalty. But our own Indian scientists who are at the helm of FIs, they supported this mechanism of the royalty. You see, if you pay the royalty efficiently, the vectors, the royalty will go to the firm. The vectors will be through mobilized to the plant, knockout will happen, you will get the high yielding varieties. But that is not true from the Indian context. For example, now the pineapple, pink colored pineapple has been produced with the genome editing technology. So one fruit costs $400, including the royalty. Whether we can pay that much amount? No. Rather, Indian context is impossible. Nobody, even a developed nation, they are also very conscious. So the need for stronger IPR protection in India is very, very important. So the incentive mechanism, innovation incentive, that is why startups were supported by the Government of India. Similarly, the foreign investment also, gates have been opened. If you collaborate with an outside firm through FDI, we can collaborate with them and do that one. And brand protection, India is giving a protection to the brand protection because these are all contributes to the economic growth. Because the startup ecosystem in India contributes only to the 4 to 9% out to our GDP. In Brazil, the entire country's GDP gets a support of 29% from the startup ecosystem. That's why when Prime Minister visited a couple of years ago for a BRICS conference, they understood this one. Irrespective of the politics and other things, every state they dump funds to promote the startup ecosystem. Because ultimately, innovation happens, patents happens, taxes will come, and economy will boost. The target is by 2035 or 2047, it should break minimum 40% contribution to the economy. So India's institutional framework is also very, very important. Various organizations, agencies were there promoting at the industry level, MSME level, small and medium enterprise level. Everywhere support has been extended by the government. So these are all the recent development. That means digitalization, as I mentioned, that has helped a lot. And the economy, just now as I mentioned, it is not alone to the pharma field, it is not alone to the biology or plant field. Even in medicine, health, Ayurvedic, allopathic, everywhere, every field, every automobile industry, engineering industry, everything. So the government initiatives like national IPR policy, GI registration, that means geographical indication things. Now everybody, that slide I will show you, and Make in India and Made in India concept. So the Made in India concept you all might have seen during the COVID time. Now, Make in India concept is also important. Both there is a difference, I think you might be knowing that one. And the modernization of IP offices to give very fast track monitoring and awarding the patent. There are dormant patents. As I mentioned, every patent, everybody will not be a successful. These are called zombie patents. So in United States alone, you see, numerous studies have suggested that up to 90% of the patents in general in the world are in the dormant stage. So you are locking your innovation, but nobody is there to take it up. Need not necessary, but sometimes to protect your own GK and general knowledge and novelty and the country's interest, you will do it. In US alone itself, 1.5 to 2 million active patents are estimated to be dormant, and market analysis that over 50% of the patents granted by US patent are uncommercialized. In India, out of 2.28 lakhs patents, only 4 to 5% of patents, whether it is government or private, are commercialized. Now, just a couple of things to fit into the theme I would like to mention on the chemistry related one. This is very tough, as I mentioned, the rest of the things. See, even in our system also, most of the things are food processing and food related thing, engineering aspect, fabrication aspect, those things will venture. Only the pharma industry is actually in the front line to have a patents on the chemistry aspects. Of course, some labs like NCL Pune and IICT Hyderabad, they are all there. The chemistry, because it pertains to all different aspects of the chemistry, including the nanotechnology wise aspect of it. Because again, nanotechnology is like a bridge between 8 different roads. You can say every subject is having nanotechnology, but everything is chemistry. Again, this background is important. So the depth of technical disclosure required for chemistry patents makes working with the experienced patent attorneys. You need to 100% approach the attorneys, because that is why chemistry patents, again, if you see, before going to that one, you see, out of the throughout the world, whatever the patents has happened during the last 5 years, 6 years, if you can see, there is a huge jump. The jump is constant, maybe 10% or 15% improvement. That growth is steady. Chemical patents are having the maximum, 14 lakh, 19, like that, compared to the rest of the things. Again, the number of chemistry patents filed in Germany and US are more, okay? But engineering patents are more filed in Asian countries, China and other things. Biology things, of course, India and other countries will be there. The reason is Chinese government run by engineers, US government run by attorneys, lawmakers. He was there in 3 decades in US, long time. 42nd presidency of US so far, 28 are lawmakers. Okay, in the chemistry, the major challenges associated with the utility requirement. First, you have to define what for it is, what utility. Second, when the speciality of chemical patents is claims must be extremely precise. Precise means precise. For example, you have kept on this table, red color base, this projector. If I dance here, it will fall. Because the base is very small here. The precision is very, very important. That means your projector weight should withstand to the seismic waves of whatever vibrations happen here. So that's like that. The prior art in the complex field. The chemistry subject itself is a very complex. There is no, like in biology, for example, any pathway, phenyl propanide pathway. Starting is pal phenylamine, end product is like vanillic acid or vanillin. 16 steps are there. Okay, I can say like this. This is a straight pathway. Any bifurcation means another compound, but it's not like that. Functional group variation will be there, means it will hit. Then data and experimental evidence. Come to know chemistry patent gives you 100% evidence. I will show you one example. International considerations. Country to country requirement. In India means ಓಕೆ ನಮ್ಮ ಇಂಡಿಯಾದಲ್ಲಿ ನೀವು ಫೈಲ್ ಮಾಡಿ ಸಾಕು ನಮ್ಗೆ ಪೇಟೆಂಟ್ ಸಿಗುತ್ತೆ ಅಂತ ಹೇಳ್ತಾರೆ. ಇಟ್ಸ್ ಕ್ರೆಡಿಟ್ ಟು ಗವರ್ಮೆಂಟ್. ಜರ್ಮನಿ ಆ ಥರ ಹೇಳಲ್ಲ, ಅಮೆರಿಕಾ ಆ ಥರ ಹೇಳಲ್ಲ. ಅಂದರೆ ಅವ್ರ ರಿಕ್ವೈರ್ಮೆಂಟ್ಸ್ ಆರ್ ವೆರಿ ವೆರಿ ಸ್ಟ್ರಿಂಜೆಂಟ್ ಲೈಕ್ ದಟ್. ಸೊ ದ ಪ್ರೊಟೆಕ್ಟಿಂಗ್ ದ ಪ್ರಾಸೆಸ್ ಆ್ಯಂಡ್ ಆಬ್ಜೆಕ್ಟ್ಸ್ ಆರ್ ವೆರಿ ಇಂಪಾರ್ಟೆಂಟ್. Just one example, if it is a pharma-based one drug, new drug, if you want to release, the basic science generally 2 to 5 years it will take. Okay, higher end 5 years. Then preclinical studies, in vitro cell culture studies or like that laboratory studies you have to do. That takes 1 to 2 years. Then clinical trials, experimental level 1, 2, 3, tier 1, tier 2, tier 3 you have to do. 7 years it will take. Then government approvals, if you are lucky, fast, otherwise 2 years, 3 years it will take. Finally your drug will be approved. You calculate almost 18 years. So an young mind like him, if he joins there, if he identifies that one, by the time he crosses his moderate age around 40 to 50 years, then he will be able to release the drug. So in pharma, that much strict things are there, but not in biology. Do you agree? Correct. So the scientists are scientists, and the patent lawyers are patent lawyers. There is a huge philosophy lying behind this statement. The compartmentalization of roles leads to a reduced understanding of the invention to be patented and the little appreciation for one another. This fellow will not appreciate this fellow will not appreciate this fellow, but they both are interdependent to do the job. That exactly fits with the chemistry patents. IP professionals are not accessible to the average bench citizen. As I said, so many agencies are there. You will approach that one. They will help you to file the thing, file this one. Up to that level only his job. Once you go to that level, then the queries and all things, you have to defend. You have to generate your knowledge. You have to approach again privately some attorneys. You have to pay huge things. So that is very, very important, you should understand. The dark side of the chemical-based patents is not always highly defined or identifiable. It appears to be the cumulative effect of factors inside and outside the patent itself that leaves the chemist perplexed and reticent to full engage with them as a go-to source of information. That means once you step in only, you will be knowing the more things. External things, appearing things are different. Hardcore subject-related intricacies are different. So whenever you have to go to the particular zone, you have to resolve that issue. One such example is market structures. Here the good is there, the bad is there, the ugly is there. Ugly means the worst thing. I mean very difficult. In the US language, that one we don't use ugly. The structure, for example, here one structure is there, one functional group, and R1, R2, R3, R4 are here the R1, R2, R4 are simple structures with the hydrogen atoms. This is a good thing you can say. See, while making a claim, my structure compound is having at so and so position, this is an hydrogen atom, up to that level you disclose. The bad thing is the next step. The bad thing is underneath the initial disclosure claim, where R3, here this R3 is there, here, okay, is described as a substituted phenyl, and R5 is described as a substituted or unsubstituted phenyl. The terminology you see, he would have declared it is a phenyl, substituted phenyl, that means like that. Idu substituted or unsubstituted phenyl. In Mahabharata, Ashwatthama Havat a slow voice. A pronunciation is also important, the same thing. So that means there is some ambiguity you are creating here. There is no clarity that one. The query will come, your patent will be stopped, then again you have to approach that one, you have to dig out the literature and provide substitution. There is ambiguity and doubt. What is the phenyl substitution pattern at R3? Is the R5 phenyl group substituted, is the unsubstituted, unsubstituted? These are all the things we will get. And the most worst thing is R6. What is that? However, this is nothing compared to the ugly of the R6 designation, which is over a page long and occupies the rest of the claims in the European patent. What lies ahead are unrefined chemical substitution definitions that further define unrefined definition. The language you see, I have not purified. For example, something is there, I have not identified, or I am not disclosing that particular things could be there or there like that, that he will give. It is very difficult. If you dig it out for this one example of this one, almost 100, 200 pages document will be there. For a normal person like us, whoever is filing, it will be very difficult. You have to pay a hefty page only for forget about your patent to defend this R6 thing, this one. In India, for example, you may not ask, but in US they may ask because money. Every document you have to pay the money. Now you understood how difficult it is, the chemistry patent. So the chemical patents are types of chemical. Now chemical patent translation is there to help us, the people. normal person, even if you go and pay money and buy a patent, so you want to release the product, you may not understand everything. To help you, now translation mechanisms are there. So whether you can, by translating how it will be helpful, whether it is useful for you to run a cosmetic product or petrochemical product or industry chemical product or paint or whatever pharma, everything you can do, or whether you want to use in agriculture. So that much help is there, that much technology has been developed and things are available. So the perspective take home message is, in chemical and research and development, innovation creates value, but protection secures it. That is very, very important. This is applicable to any patent. A formulation without a strong claim is gets exposed. You will be out. A well-structured formulation becomes a strategic effect. That means a strategy, your attitude, logical thinking makes a lot in protecting your document. Otherwise, somebody will bring something. Oh, you got a patent, you got this one, you already bought it for 5 lakhs rupees. You see, this is the one, I got this one. This literature has been missed. That means your patent faces infringement. You will lose the patent, you will lose the 5 lakhs also. Just I am telling you. So if you are serious about building long-term impact in the chemical industry, understanding patent claims is no longer optional. It is a must. There is no other way. Now everybody is talking about GI, geographical indications. So Mysore also we are having Nanjangud Rasabale, Mysore Mallige, Mysore silk, like that beetle leaf. These are all the GI tag products. Like in India, a number of things were there. Again, why government has initiated this one is to protect local variety, local culture and society. Whether it will give you a business or not is immaterial. By for example, Nanjangud Rasabale, we have GI tag. Do you get a business by getting this one? Because production itself is associated only with the Nanjangud soil. It will not grow any other soil. How much you will grow? Maybe very little quantity you will generate. It will not give you any business, but it is a pride that you people should understand. So every country, see, this is of Indian things. Even in the world wide, every country is having. In France, 6,000 products, Italy, 6,300. So many things are there. Well, just a couple of days back, I was in Ladakh for attending the World Honey Conclave. Like our Coorg honey, they are also having Ladakh honey. The Ladakh honey, especially through the seabuck thorn, one small fruit, it grows only in the winter for 2 months in the Ladakh region. The honey bees collect only honey from that one and it is having very huge impact. But you cannot patent it. It's only GI self-satisfaction, that's all. Whatever price it is available, that you have to buy. So the GI difference is that one. For the first time in Karnataka, the GI Mahotsav we conducted in the last October in my CFTR. It was a huge success. From Karnataka, Tamil Nadu and Kerala, many people have come and did good business also. In 2 days they did almost 12 lakhs rupees business. So this is for example Nanjangud Rasabale and all the things. So that is an important between the IP and the IP rights. Just I have given a glimpse. I didn't go much into the legal issues and trademarks and other things. They are all secondary aspects of the IPR, but the core crux is this one. So your innovation you should protect by registering, and if it is by in the chemistry, you have to toil a lot by gathering the sufficient information from all different aspects. Then only you go for the filing. Otherwise, your filing fee also you will not get it back. If it in India, maybe 5,000 like that. In US means lakhs of rupees. That is it. Okay. Thank you very much. So within the time I given, I hope I will make you entertain this one. Thank you.
Thank you very much, sir, for this insightful keynote address. If anybody has any question, now please you can interact with Professor Giridhar Parvatam. If you have got any comments from questions on online also, you can please check it. If nobody has questions, let us wholeheartedly thank Professor Giridhar Parvatam for making some time amidst his busy schedule to come to Sharda Vilas Educational Institutions to inaugurate today's workshop and also to deliver the keynote address. Thank you very much, sir, on behalf of the institution and also personally. Thank you very much. Thank you. We are now breaking for tea. Tea has been arranged in the front hall. After tea, we all request you to assemble in the AV hall. The next sessions will go on in the AV hall. So those who have not registered yet are requested to register in the front registration desk, and those who have not signed the attendance also, please sign it.